الحمد لله رب العالمين والصلاة والسلام على رسوله الكريم ومن استنى بسنته إلى يوم الدين. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. اللهم ثبت عند الموت بلا إله إلا الله آمين يا رب العالمين. السلام عليكم ورحمة الله وبركاته. Well, what are we trying to understand in this presentation? We're trying to understand how Islamic law and especially the schools of Islamic thought, the different madhabs, okay, the Hanafi, Shafi'i, Hanbali, and other madhabs, where did they come from? What stages of development did they go through? Okay, what was the differences between them? Why these differences occurred? Okay, where are we today? What are the lessons that we need to learn from this history of Islamic law evolution? Okay, so this is the overall kind of picture. And we have discussed the different stages thus far. The first stage was the time of Wahi, the time of revelation. This is the time and Sunnah, right? The Prophet is living. Whenever there is a new issue, you just go to the Sallallahu Alaihi Wasallam and he will tell you the guidance based on Allah's revelation. So that's the foundation stage. Then came the next stage, which was the stage of the Khulafa Rashidun, the four righteous caliphs. Who are the four righteous? 30 years, about 30 years of their rule after the Prophet ﷺ's death. In this stage, new issues came up. How did the Sahaba resolve those new issues? So of course, Quran. First go to the Quran. Second, you would go to the Sunnah. But third, if Sunnah is not giving you an answer, the Quran has no direct answers, then the Sahaba would go to a third source, and that was called Ijma. Ijma, which means consensus of scholars. So scholarly Sahaba, they had a committee. Whenever a new issue would come, this committee would discuss this issue. This was basically of Sahaba, right? So this committee would then make decision, and obviously the Khalifa would have the last word. If it's the time of Abu Bakr as-Siddiq, then after discussion, after making shura, whatever Abu Bakr says, whatever opinion he chooses, he will go with, everyone go with that. Umar ibn al-Khattab, when he came into rule, once again the committee is there, but at the end of the day, it will be his choice based on different opinions. Of course, if it's in Quran, there is no discussion, right? We're talking about issues which were new, which are not directly addressed by the revelation. So there's the second stage, the stage of the Khulafa Rashidun, Banu Umayyah dynasty, okay, which was started with Muawiyah radiyallahu anhu. Muawiyah radiyallahu anhu, and then his son, and then his son. So now a dynasty begins. It's no longer a khilafah. In khilafah system, you don't have like a dynastic rule where the father dies and then the son becomes, and then the son dies. It's not like a kingdom. Khilafah is based on merit, choosing the best person to be leading. But now Banu Umayyah dynasty began, okay, after Muawiyah radiyallahu anhu. So now a source of Islamic law was added, and that was after, because now the Ummah had spread far and wide. Scholars from the east did not have access to the scholars in the west. Muslim empire was very large by that time, right? So what would happen is the local scholars obviously would try to come, and they had students, and these groups started following the opinion of that scholar. And we said around this time, two schools of thought emerged, which later on developed into many schools. Two primary schools of thought emerged in the 100 years after the Khulafa Rashidun, in the time of the Banu Umayyah. One was the Ahlul Hadith school, which was in Medina, Makkah, Hijaz area. Ahlul Hadith school. Okay. The other was the Ahlul Ra'i school, which was in Iraq. So now these two major schools of thought are developing together, parallel. Medina, Makkah, Hijaz area, they are Ahlul Hadith, meaning they don't like to get into opinion. They like opinion. They want to stick to the Quran and Hadith. They have Damascus in all these areas. So there is relative peace in Makkah, Medina. Religion is very poor over here. Okay. On the other end, Iraq, all the politics is going on. Okay, that's where the capital was moved in the time of radiallahu anhu. Okay, that is where there is extremist groups. That is where there is the Sunni Shia split really playing, a big role. That is where people are lying about hadith. So the scholars of that region, they said, instead of relying on the hadith narrations which we have, which they did have, but they did not have the authentication of the hadith yet. Right? Like today we know each hadith. Scholars of Iraq, they said, let's rely most on opinion. Okay? Yes, Quran and hadith, whatever is there, but we cannot trust a lot of hadiths because of all these problems that are going on. So they gave preference to Ra'i, or opinion. Okay? So two schools in parallel emerge in the Muslim world, Ahlul Hadith school and Ahlul Ra'i. So that is the third stage. Then we are talking about the fourth stage. Fourth stage is the next 200 years of the Abbasid era. Okay? Time of the Banu Abbas. After Banu Umayyah, which dynasty came? Two different times. The first 100 years of Banu Abbas, this is the time of the major Imams. The major Imams like Imam Malik, Imam Abu Hanifa, Imam Shafi'i, Imam Ahmad ibn Hanbal, okay? Imam Auza'i, there's others, Imam Layth. There's many ulama at that time who have their own schools of thought. Okay? Now we only have 4 left, and we will discuss what happened to all those other madhabs, all those schools of thought. We're going to discuss that later. But at that time, there were hundreds of schools, literally. It was not just the 4 that we know. There's 100 Imams and hundreds of schools of thought, and they had followers, and they have their own opinions on different matters, and so on. That is the age of the major Imams. This age was marked by tolerance. The other Imams also have knowledge. Okay? There is mutual respect, there is travel. Imams are traveling to each other, learning from each other. So this is kind of like the golden age. The age of the major Imam was the golden age of the Islamic fiqh. Okay, or legal schools of thought. Then this was followed by the next 100 years, which is the time of the. These are students of those major Imams, or students of the students of those majors. So this is like the second or third generation after those Imams. This period is marked by few things. One of them, the compilation of fiqh. This is the first time now fiqh books started coming out. Okay? Before this, it was just those schools of thought within them, writing from the scholar to the students, right? Now fiqh books started emerging even for the common people. So the common person can learn what is Hanafi fiqh. The common person can learn what is Shafi'i fiqh. Okay? Compilation of fiqh books. Lots and lots of fiqh books started going around in the Muslim world in the age of the minor. Owner of a land, as part of the court system, would have scholars of different schools of thought, and he would give them a topic. And what do both sides have to do? Debate with each other. So the Hanafi scholars have to debate with the Maliki scholars. The Shafi'i scholars have to debate with the Hanbali scholars, or whatever, right? So after some time, all the issues are gone. So now you try to make up issues. What if? Just like kids, little kids, they ask a lot of questions, right? They say, what if this happens? What if that happens, right? So that's what the Muslims started doing of that time. In order to say, what is the ruling of Shafi'i fiqh on this issue? And so a Hanafi Shafi'i scholar would come in the court, they would debate, try to outdo each other. At the end, one would win. The one who would win would be given gold, silver, a lot of money from the king, from the Khalifa, from the governor, and he will be hailed, my school of thought won. And the other one who would not win, it becomes what? Personal. Now it becomes competition. Now this fiqh is no longer to know the truth, but it is to prove we are right and you are wrong. Okay, so now this is court debates which begin in the second 100 years of the Abbasid era, and that is in the age of the minor Imams. Another thing which happened in this time was the compilation of hadith. This is now the time of Imam Bukhari, Imam Muslim, all these great hadith scholars who are trapped. This hadith is good, this hadith is weak, this hadith is hasan, this hadith is da'if, and all those different categorizations of hadith. So there is some good also going on in this time of the minor Imams. Any questions before I move on? This is like a quick summary of where we are right now, because maybe some of you have not attended previous sessions. By the way, all these sessions are on YouTube. If you have missed any of the previous one, go to the Masjid YouTube channel and you'll find them there. Okay, today what are we talking about? Today we are talking about the sources of Islamic law by this time. So what are the four so far up until this point? You have Quran, Sunnah, Ijma, and Ijtihad or Qiyas. Okay, most scholars. So let's look at the development of the sources now. Quran will always be number one. The first thing you go to is the Book of Allah whenever you want to find an answer to something. Number two, Sunnah, the Prophet ﷺ's life, because that explains the Quran. It gives us understanding and interpretation of the Quran. The third one was the opinions of Sahaba. So this has to go back to Ijma of the Sahaba, because their opinions were also ruling. See, so their rulings also became part of the sources of Islamic law. This is like, in the Supreme Court, one of the things they follow is what? The previous rulings, right? So the lawyers, when they are debating each other, what do they say? 1953, the Supreme Court ruled on this issue. Our issue is the same issue, so it has to have the same ruling, right? Without what Umar ruled, or what we should go with what the Khulafa ruled. Number four was Qiyas. Okay, now you see, Ijma is not there in this list. Okay, why do you think ijma is not there? I mentioned the reason slightly in passing. I mentioned to you. For ijma, what do you need? What are the things need? For the scholars to this was very difficult. Most of the times, the scholars would get together on Hajj. Hajj was the way, so scholars from Iraq are coming, scholars from general, it was not possible. Obviously, there's no Skype, there is no internet, there is no Zoom, right? So they did not have the facilities that we have today to make that kind of a conference. Now, another one is added in this time period, and that is called istihsan or. Okay, so these are two that are added in the time of the minor imams. These did not exist formally earlier times. Okay, so let's look at these. Quran, as we have said, the Quran was the first source of law, and its passages were accepted unanimously as being authentic. Has the Muslim Ummah ever disagreed on the Quran? Said this is the Quran and this is not the Quran? It has never happened. Okay? Because from the Prophet sallallahu alaihi wasallam, his focus was always the preservation of the Quran. That's why the Prophet didn't focus too much on hadith preservation. In his own lifetime, what was the focus for the Sahaba? Quran. Went to Abu Bakr and said, we need to write it down. Okay, so it was compiled, written down in the time of Abu Bakr radiallahu anhu. Then it was standardized the time of Uthman. Okay, in the time of Uthman, what happened was Islam had reached area. Give you a Quran without dots. How would you read it? Would you know how to read it? Subhanallah. Even if you're an Arab, you cannot do it now. It's very difficult for even an Arab to read Quran without the dots. So that's how the harakat were not there. Fatha, kasra, dhamma, all these tashkil. None of them were there. So what happened incorrectly? They started reciting the Quran in a wrong manner. So that's when Uthman ibn Affan, he collected all the copies, he burnt all the other Qurans which had different writings in, with obviously the dots added later and the harakat added later and so on. However, there were some differences of opinion in the interpretation. So that's where the differences were, right? Muslim scholars, they never differed on scholars would take the same verse in a different way. So that's where differences of opinion were always there between the scholars. Hadiths of the Prophet ﷺ were next in importance. However, scholars of their acceptance and application set various conditions. Okay? So hadith, as I said, up until this point had not authenticated, meaning formally authenticated. It's not like individual scholars did not know. The chains of narrations were there. They were passed, put this chain in this category, this chain in that category. Why? Because the early hadith scholars watch everything. We will collect good, we will collect wrong, da'if hadith, good hadith, bad hadith. Let's get all the information first. So the earlier scholars of hadith, their focus was collection of hadith. Now the later scholars, now they can sort it. Say, okay, this hadith should go here. Either as a group or individually was considered the third most important source of law. Which one would take precedence? Opinion of the Sahaba, collective opinion, or individual opinion of different Sahaba? Pretty strong. But if you cannot get that, then you start looking. What did Ali say? What did Aisha say? What did Abu Bakr say? What did Uthman say? And then you start looking at the various opinions and their merits. This source was divided into ijma. So that's where ijma was. Ijma of the Sahaba, personal opinion. So both of them became sources of law. The ijma of the Sahaba, very strong source, but also the individual opinions on different issues. Imagine you have an issue where you have the opinion of Aisha radiallahu anha, and then you have the opinion of Imam so and so. Which one would you give preference to? Aisha radiallahu anha, because she has authority, right? She is level of Aisha. Never reached the level of Huraira, never reached the level of Umar ibn Khattab. So, individual Sahabi on an issue, they would give that preference over Qiyas, ijtihad based on evidence found either in the Quran, the Sunnah, or Ijma was the next in order of importance. So can somebody explain to us what is ijtihad? We hear this word a lot. What is ijtihad? How would a scholar do ijtihad? So they research the subject matter, and then what? What do they do? Because remember, if it is in the Quran and Sunnah, you don't need research. All you need to do is just go to that ayah, go to that hadith, and that's your answer. What does the scholar do in ijtihad? They will only do ijtihad if the answer is not there in the Quran and the Sunnah. So what are they really researching? What are they really doing? Yes, meant. So interpretation, you mean interpretation of certain texts. Okay. What else? So yeah, you're right. Interpretation of certain texts would be ijtihad, an effort. Anyone else here? Sisters? Ijtihad? What do you have to do to make ijtihad? What does a scholar? Mujtahid? Hardworking, yeah. Somebody who's researching, struggling, making effort. It's like a jihad. What are they really doing? If it's the answer is not in the Quran, it's not in the Sunnah, then what are they really doing? What is ijtihad? What is the effort? What's the research about? Yeah. So that is similar to what he said, like interpretation of the verse. Okay, that's fine. That's one part of it. But then that is the third source. We said this is a source by itself. That was another source, the opinions of the Sahaba, the Quran, the Sunnah. Yes, Omar? Okay. Okay, so helping, like asking people knowledge, you mean? Asking other scholars? Okay. Yes? Google that. Their family, yeah. That's a good idea. Do you ask your family members when you sometimes? Other times you take things in your own hands? Yeah, so you guys are close. So what an alim will do in the case there is a new issue and there is no direct evidence from the other sources. Yes, sister? Mhm. So that one would be categorization of hadith. That wouldn't be ijtihad. Ijtihad has to do with an alim's own effort to the right answer. Yes. Yes. That's what it is. Analytical or deductive reasoning. Can you explain those a little bit more? What is analytical or deductive reasoning? Hmm. Yes. So that's a very good example. It is so that ijtihad, the process of ijtihad could include tools like qiyas. Qiyas would be to compare your new issue, which is not addressed in the Quran and the Sunnah, with an issue which is addressed in the Quran and the Sunnah. And saying these two issues are similar. And so, whatever the ruling was for issue A should also be ruling for issue B, because they are similar, right? There you go. Yeah. So, for example, in Islam, drugs, are they halal or haram? Haram, right? Drug, inflict harm on your body or whatever, they are haram. Now, is there any direct ayah in the Quran or Sunnah about drugs, drug abuse? No. There's no direct hadith or direct ayah in the Quran which talks about drug abuse. Then why is it haram? Why did scholars say it is haram? Hmm. Yes. 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 Go ahead. Go ahead. And harm body. Yes. You're right. You're very intelligent, mashallah. Anything which will harm your view. Okay. So your ability to differentiate between right and wrong, right? So the scholars, they say in the Quran, Allah subhanahu wa ta'ala has clear men are talking about. It takes away your ability to think, to go to reasoning, to make right and wrong decisions. So they say anything then which would do the same to your body would also have to be forbidden. So even though there is no direct ayah in the Quran and the Sunnah, but this is thing forbidden. Smoking. Why is smoking forbidden in Islam? Haram. Yes? It harms your body. Yeah, and what does Allah say in the Quran? وَلَا تَقْتُلُوا أَنفُسَكُمْ. Yes. It's haram, yeah. It is, you're right. So what happened with smoking was, when there was not a lot of medical research on this, the earlier scholars, if you go back to early scholars, when cigarettes were introduced in the Muslim world, or forms of smoking was introduced in the Muslim world, what was the earlier ruling? Disliked, but not haram. What did they base this ruling on? They said, because when you smoke, it's bad smell. Your mouth gives bad smell. Those around you will be affected by bad, and bad smell is not haram, right? It is disliked. Is disliked. So they gave the ruling it is makruh. Some people even today not haram, is makruh. But if you look at the current scholars, ulama around across the Muslim world, when the research came out that smoking causes cancers, smoking can cause illnesses, smoking can have health consequences. When this new research came out, they changed their ruling. They said, no, true anymore. Haram. Haram change with time. When new information comes, the scholars they will reevaluate. So this is the process of ijtihad. Ijtihad would be to look at the evidences which are there in the Quran and the Sunnah and see if there is any link, not a direct link, indirectly, right? Because if it was direct, then you don't need to do research, you just go and follow it. But you see if whatever is there, can we apply it? Another tool is comparisons with old situations and on. So this would be ijtihad. Any questions on that? The method of reasoning used was a form of analogical deduction called qiyas. Okay, I already gave you the example. So, for example, the prohibition of marijuana is based on the Prophet's statement, every intoxicant is khamr and every form of khamr is haram. Okay. Now, is something interesting about this hadith. This hadith was not available to Imam Abu Hanifa. In his time, this hadith had not reached him. Okay? So can you imagine Imam Abu Hanifa thought that certain kind of alcohol is okay, you can drink it. He's such a great alim of his time. But he made the mistake. Why did he make the mistake? Because this hadith was not available to him. The Quran says what? Khamr. Right? The word used in the Quran is khamr. So what is khamr? Khamr is a specific kind of alcohol which is out of grapes or dates, the date fruit. Right? So Imam Abu Hanifa said other alcohols are okay because only says what? Grapes or apple or whatever. They are all intoxicants and they are all considered to be khamr. That is why when we look at terms in Islam, there could be an Arabic language meaning and then there could be Shari'i meaning, Islamic meaning. So the word khamr in Arabic language means what? Means a very specific kind of alcohol. Alcohol which comes from dates. That would be khamr. Other kinds of alcohol, according to Arabic language, are not khamr. Okay? But in Islam, how do we understand the word specific kind of alcohol? This also shows how the early scholars, they were handicapped. They didn't have all the hadiths available. Okay? And the later scholars, they had more. Muhammad, he changed his ruling. He said, my alim, he gave this ruling, but it was wrong because now the hadith had reached him by this time. Since marijuana has an intoxicating effect, it can be classified as khamr, and thus we haven't said this before. Istihsan. Istihsan, which is translated as legal preference. This principle involves the preference of an opinion based on a circumstantial need over an opinion in Sunnah which is similar to our situation, right? Looks similar, both situations look similar. So qiyas would say, okay, whatever the ruling was there, we're going to follow the same ruling here. But istihsan is the opposite. Istihsan would say, even though they look similar, okay, but we are going to follow different ruling for the new issue. Because this new issue, if we use that same rule from the from the original text, it is going to cause some harm to the community, to the people. So we cannot use that original ruling in this case. We have to go with what is better for society, what is better for people. Okay? So let's look at this. This principle referred to by various names, they just called it different. One school of thought would call it istihsan, the other would call it istislah, but at the end of it, it is public benefit. Okay? Ruling which will benefit the public. An application of istihsan is seen in the contract for the manufacture and sale of an item. Okay? When you manufacture something, not do so until he has it in his own possession. What's the ruling for food items? Let's say you grow grapes, okay, or you have apples. What? Oh, look at the tree over there, brother. This is my tree, and all the apples are my apples. So give me the money. Let's have a deal. Do not do that until you pluck them, you package them, ready to sell them. You're not allowed to sell. This is the basic ruling for products, okay? For food products, right? This is reported by Imam Malik in Al-Muwatta. That's the basic ruling. Can you do a contract of an item which doesn't even exist? You don't even have it with you, and you are selling it to somebody. Are you allowed to do that? No. That's the basic ruling. So that is based on the Prophet ﷺ. Need for such contracts is obvious. The ruling by qiyas was dropped, and the contracts were allowed based on the principle of reference. So even though there is a hadith about stationery, let's say I have a stationery shop. Can I sell you pencils? And I don't even have pencils yet with me in my warehouse. According to this hadith, I cannot, right? But comparison with food items which the Prophet prohibited in that time, then it would cause great harm. Because what is happening around the world? I am selling you, getting the money, getting the stuff, selling you, it's like rotation is going on. Right? There's a rotation going on. Okay, let's listen to the adhan. Allah. أشهد أن لا إله إلا الله أشهد أن لا إله أشهد أن محمد رسول الله
حي على الفلاح، حي على الفلاح. الله أكبر، الله أكبر،
الله أكبر الله.
لا إله
لا إله إلا الله. اللهم رب هذه الدعوة التامة والصلاة القائمة آت محمدا الوسيلة والفضيلة والدرجة الرفيعة وابعثه مقاما محمودا الذي وعدته وارزقنا شفاعته يوم القيامة إنك لا fit is given precedence over qiyas. Okay? Qiyas tells you to go in one direction, but public benefit tells you that direction is not good because that will harm the people, it will make life difficult for the people. So the scholars, they lean towards public benefit in that case. Even though their analogical reasoning, their deduction is telling them you should do the opposite. Okay? So here one thing should be clear, similar is there in the hadith. And so you can compare the two situations and you can follow that ruling. But you say now, these companies that make fighter planes, you know, can you imagine scenes or whatever? I want 12 of them for my Air Force or whatever. Do you think the company has their 12 ready for them and say, look at these? No. They will first do a deal with you. Okay, you make the payment. And now we will make those for you. Because these are $1 million, millions of dollars of planes. They cannot just invest millions of dollars, put them on display here, and maybe nobody is going to take it. So it's made order. If we follow the IAS process, these companies will be, shut down. They will not be able to do business anymore. Okay. Some people have very feet, and their shoes have to be made on order. Right? Those shoes are not made ready. You have to please make a special shoe for me. The point is not every place you will follow the rule. Yes, that's what the ulama is saying. Some place to see if that is going to cause, they would people to make life hard, make life easy. And if a ruling is going to be difficult and is going to block their means of sustenance, block their means of living, then that ruling cannot be from the Sharia. Sharia is always going to provide ways for people to. So we're talking about needs here, not talking about wants. See, this is the difference. Some of us, we also use this ruling for wants. I want to have this thing, so it's allow me. No, we're not talking about wants. Talk about things that you need to survive. Those are the areas where the Sharia will be flexible with the rulings. And Allahu Alam. So, any questions on istihsan or istislah? Is it clear? Yes, brother? Mm. Mm-hmm. Yes. If it is any of those food items which are directly mentioned in the hadith, then you cannot do that. The dates, the barley, there are specific items mentioned in the hadith. For the other items, using this law, the Islamic scholars allow that. Many of them will allow it based on this is the way things are done in that industry. If we follow the qiyas methodology, it will cause unnecessary harm to them. I'm coming to you, brother. Oh, I'm sorry. The brother is asked a question about certain companies who have contract with the farmers, and the contract is they're going to provide them with certain things like chemicals, fertilizers, whatever, in return for food items. Okay, and they have the contract that if those items, food items, are not covered by the hadith, then they would go in the category of comparison, right? And so in that case, istislah or istihsan, many scholars would go that way and allow that to happen. And Allahu Akbar. Okay? Inshallah. Any other questions on this? Okay. So 5, right? 5 sources of Islamic law. Quran, Sunnah, Sahaba, Ijma of Sahaba, and then Qiyas or Ijtihad of individual scholars. And then the 5th one we said, Istihsan or Istihsan, which has to do with public benefit. Okay? The last one, another one which was recognized by many schools of thought, was urf or custom. We can also call it culture. The culture of the land you live in. So even that can be used as a source of Islamic law. Not number 1. Then the Islamic scholar will say, okay, now let's see what is the culture of this place, and we can go according to that, as long as it does not contradict the earlier ones. Local customs were accepted as a source of law in a given region, as long as they did not contradict any of the principles of Islam. For example, local marriage customs concerning dowry payment. Now, when many people get married, have you heard the term mu'akhar and mu'ajjal? Meher, part of it now, part of... Is this from the Sunnah? Did the Prophet have mu'akhar and mu'ajjal in the meher? No, there was no concept of mu'akhar and mu'ajjal. Meher was meher, you have to pay your wife that meher, right? But in many cultures what happened is, there was this system adopted based on local customs, that part of the meher will be paid right now at the time of the kitab, at the time of the nikah. Part of it will be paid if X and Y happens. For example, if divorce happens, or within 10 years, or 10 years, or whatever. So Islamic scholars looked at that and said, this does not go against the Sunnah. Her wali agrees to it, then they said it is culture, it is okay. So this can be adopted. There is no problem. In this case, culture could be adopted. The dowry meher, according to Islamic law, must be agreed upon as part of the marriage contract, but it has no set time to be paid. It is the custom, for example, Egyptians as well as others, that a portion of it is called muqaddam, must be paid before the marriage ceremony, while the remainder, called mu'akhar, is only required to be paid in case of death or divorce, according to whichever comes first. Okay? So that is an example of urf, which was adopted by Islamic scholars. Another example of urf can be seen in rental customs. Islam law does not require the payment of a price until the thing being sold has been delivered completely. This is another basic law in Islam, right? That you don't have to pay unless you have received what you are paying for. That's the basic law. However, it is the accepted custom that rent is paid before the rented place or object has been used for the agreed time. Do you pay your rent on the first? Not even started living in that house, you have to pay deposit, you have to pay rent. You have not used the service yet. So this is custom, because if this is not followed, what might happen? A person might live in the house for the whole month, and then 30th, they pack their bags and they're gone. So that might cause harm to the owner of the house or that particular. So rental contracts would also be under urf or custom in many cases. Although this process of organization and classification was, for the most part, positive development, nevertheless, when coupled with the prevailing trends towards factionalism, it served to further widen the gaps between the madhabs. So this is the problem with this one. Even though the early scholars, they allowed this urf to make life easy for the people. People are used to a culture, so let them be happy with their culture as long as it doesn't go against Islam. But over time, what happened? These became so strong. This number 6 became so strong that there was factionalism, division. Oh, we do it like this. Another example comes to my mind related to urf, dress. We know in Islam, the men and women not dress like each other, right? That we talked about it when we were talking about gender roles, right? Skirt. Are men allowed to wear skirts in Islam? We're talking about the women's skirts that women wear. Okay? Not allowed to wear. But if you live in Yemen, are you allowed to wear a skirt? Yes. Why? Because in Yemen, that is part of the dress of the men. It's like a long skirt. In other cultures also they have similar. Scotland, you seen the Pied Piper? What is he wearing? In Scotland, again, the dress code for men included a skirt. So this culture for 100 years, that's it. In another place, that would be a problem. So this is a ruling based on where you live. In some places, it is part of the culture for men to do it this way, women do it a different way. Then you go and you are allowed to do that because that is urf, that is what people are used to. Yes. Okay, so you tell me when I come to your place, is this acceptable or not? I'll follow it's acceptable? Okay, alhamdulillah, alhamdulillah. So yeah, you have to follow, the urf, as long as it does not go against Islam. Thus, we find slight variations in the terminology given to the same principle that led to friction and opposition. The Maliki madhab considered the Hanafi principle of istihsan unacceptable, yet applied the same principle under the name masalih mursala. So you see, this is the problem. This is now later scholars. We're not talking about Imam Malik and Imam Abu Hanifa. Later scholars, when there is divisions, there is tensions between. So what is the Maliki scholar saying? Hanafis, they use this. So they're both doing the same thing, but they have different names for the same thing. And there is tension between the Hanafi and Maliki scholars of later times because of this. While the Shafi madhab rejected both of these and applied the same concept, istihsab, which is a different name for the same. So the Shafi said the Malikis and Hanafis are wrong. They cannot use this. And they themselves are using it under a different title, istishab. So this is the problem which happened in the later period. Any questions on the 6 sources of Islamic law by the time of the minor Imams? Okay. Yes, you have a question? Like shipping online? Yeah, inshallah, that's fine. That's what I said. That's why this concept is there, to make life easy. Otherwise, it would become very difficult. You'll say, hey, Amazon, I haven't received my box. Until I receive it in my house, I'm not going to pay you. Right? Then Amazon is not going to send you anything from there on. So, this is how the systems other questions or comments? Yes. So jewelry, once again, I don't know if there is any cultures around the world where men wear jewelry. I don't know. Do you know? Is there a specific culture you're talking about? I mean, gold is forbidden no matter what for men, right? Whether it's because that would then go against the earlier sources, Quran and Sunnah. But if in a culture men wear certain kind of jewelry, which I don't know, I've not seen too much of cultures where this is common, then there might be room for it. Allahu Alam. Okay. Yeah, but it is not the culture where it is common that every man. See, I'm talking about cultures where it's predominantly the culture that most of the men will wear that skirt, or most of the men, will wear certain. But this one is, you don't find most people out there wearing it. It's actually then it would qualify as a problem because primarily women who do it, and then men are trying to imitate that, and that would be an issue. Allahu Alam. Yeah. Yes. 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 Okay. Before he does that. Yeah. So every culture has their own understanding, and the sister is saying, in her country, the mu'akhar, the deferred payment of meher is paid when the husband takes a second wife. So when he gets married to somebody else, then he has to pay the first wife that part of the meher. Yeah. Any other questions or comments? Okay. Yes. No, no. Question Brother Tariq is asking, do we think that most Imams agree in our time on different issues? The answer is no. That's why we have so many different opinions, so many divisions, so many fatwas, so many schools of thought, every country, and then there is masalik, and there is madahib, and there is all kinds of divisions in the ummah. So this is a problem which we are facing, and we're going to come to that. See, we haven't finished this yet. This is still, now starting the decline. We have reached the golden age of Islamic law, the good part. Now we will see how it goes down until our time, inshallah, in the coming session. Okay, let's go over a quick summary of this stage 4. Okay, what happened in this stage of flowering? Fiqh took on a definite shape as an independent Islam. This time what happened? It was joined with the other sciences. It's part of the Quran, part of the Hadith, part of the other sciences. But now it is taking its own shape. The many madhabs which had appeared in the latter part of the Umayyad period. Okay, can we do this later, brothers and sisters, so that we're done? Yeah, I know, but this is causing disturbance. So let's sit down. Let's finish first, and then inshallah we'll get Jazakumullah khair. The many madhabs which had appeared in the latter part of the Umayyad period flourished, and the centers of learning increased throughout the Abbasid state due to state patronage. So this is another thing we discussed. Under the Abbasid, especially the first 100, 200 years of the Abbasid era, there was state-sponsored schools of thought. The state was pouring in money, building schools, building buildings, giving salaries. There was a lot of patronage. There was a lot of help, financial help given to the different schools of thought. For the first time, the fiqh of the various madhabs was successfully compiled on a large and systematic scale. So this is the time now books start coming out. This is Hafi madhab, this is Shafi'i madhab, this is Maliki madhab. So compilation of fiqh started happen on fundamental principles of fiqh, which is the root of fiqh, and then full, which are the branches. Okay, so the scholars, they identified these are the fundamentals and these are the branches, secondary issues. The Sunnah in its entirety was also collected and recorded in books of hadith by the end of this stage. So this also is the very good time for hadith literature. Okay, hadith compilation, all the authentic books of hadith came out in this stage as well. During the first half of this period, the madhabs, under the guidance of their founders, continued to experience a great deal of mutual exchange of ideas. However, under the second generation of students, there was a trend towards rigidity and a breaking down of flexibility. So the early scholars, great Imams, and their immediate students were flexible with each other. Okay, they understood that this is not about us right and you being wrong. This is not a competition going on. It's about trying to understand the deen. But the later scholars, second, third generation, they started competing with each other for worldly benefits, trying to show that we are right and you're wrong. Okay. Any questions here before we dig into the cookies? Any questions? All right, if there's no questions or comments, we'll stop here. Inshallah, we'll continue with more next time. سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت نستغفرك ونتوب إليك جزاكم الله خيرا والسلام عليكم ورحمة الله وبركاته.